Good afternoon, everyone. Welcome to part 11 of this lecture series on the law on obligation and contracts. This afternoon, we're going to discuss about form of contracts. So let me share my screen with you. Right, chapter 2, forms of contract. Article 1356, form of contract. When you say form of contract, this refers to the manner in which a contract is executed or manifested. Now, what are the rules regarding form of contracts? As a general rule class, contracts are binding and enforceable reciprocally by the contracting parties in whatever form that they may have been entered into, provided that all the three essential requisites for their validity are present. In other words, class, contracts are not required to be reduced in a certain form as a general rule, but there are exceptions. First is when the law requires that a contract be in some form to be valid. So there are some provisions of law which requires that a contract be executed in some form in order for it to be valid. The next, when the law requires that a contract be in some form to be enforceable or proved in a certain way. Third, the law requires that a contract be in some form for convenience of the parties or for the purpose of affecting third persons. So under these three exceptions class, a contract is required to be executed in a certain form to be valid. No? So one, if the law requires that the contract be in some form to be valid. Two, to be enforceable or proven in a certain way. And then third, in order for the convenience of the party or for the purpose of affecting third persons. Now, flash in your screens are or is a list of contract which is required to be executed in a certain way for its validity. No? Number one, you have here donation of real property. No? In a donation of real property, just like house and lot, no, it must be executed in a public instrument. Okay. Now, number two, donation of personal property, the value of which exceeds 5,000 pesos. No? The donation and the acceptance must be both in writing. Now, take note of the threshold amount. When it comes to real property, if the value will be more than 5,000 pesos, then both the donation and the acceptance must be in writing. Take note, class, that the threshold amount will have to exceed 5,000 pesos before the requirement or formality of the law will apply. In other words, if the value of the personal property is 5,000 pesos exactly, then does it require to be, does the contract, is the contract required to be in writing? Answer no. The law expressly provides that when it comes to personal property, the value will have to exceed 5,000 pesos before the donation and the acceptance is required to be in writing. Otherwise stated, where the personal property is 5,000 pesos and below, then it does not require that the donation and the acceptance must be in writing. Common mistakes committed by students is forgetting about the threshold amount. Class, when you reach Article 1403, the Statute of Frauds, there is also a mention there of sale of personal property, no, for more than 500 pesos. or 500 pesos and above. No? When it comes to statute of frauds for sale of personal property, the threshold amount there is 500 pesos and above. But when it comes to donation of personal property, the threshold amount is not 500 pesos, but 5,000 pesos. Actually, more than 5,000 pesos, then it is required to be in writing. In statute of frauds under 1403, in order for a contract of sale of personal property to be enforceable, where the personal property must be 500 pesos and above, no, take note of the comparison between these two. No, these are common mistakes. When it comes to donation of real property, remember the amount there is 5,000 pesos. But in statute of fraud, the amount there is 500 pesos when it comes to sale of personal property. Okay, just take note. Now, if the sale of land through an agent, when you say through an agent, the owner of the property is not the one to sell the property, but the property or piece of land will be sold through a representative or an agent. This is common in a contract of agency. There is a principal and an agent. No? Now, in sale of land through an agent, the authority of the agent must be in writing. Otherwise, the sale is void. Now, when it comes to stipulation to pay interest, okay, the same must also be in writing. No? If there is no stipulation to pay interest, then, okay, the imposition of penalty or interest will not be valid. Now, fifth, in a contract of partnership, if an immovable property, when you say immovable property, this is also real property, or for example, house and lot, no? If you want to see the enumeration of immovable properties under the Civil Code, you just have to look at Article 415. Now, in a contract of partnership, if an immovable property is contributed, then it must be in a public instrument. Now, under these enumerations, 1, 2, 3, 4, 5, donation of real property, regardless of the value, by the way, donation of personal property, the value of which exceeds 5,000 pesos, the sale of land through an agent, stipulation to pay interest, and in a contract of partnership where an immovable property has been contributed by a partner, formalities are required. It may either be in a public instrument or in writing. When you say public instrument, the agreement must be reduced to writing and it must be duly notarized by a notary public. No? That is what is required when you say public document. So what are contracts that are required to be executed in a public instrument or notarized document? Donation of real property. Take note, class, do not apply the threshold amount of 5,000 pesos when it comes to donation of real property. The threshold amount of 5,000 pesos applies only in case of donation of personal property. Now, what else aside from donation of real property? In a contract of partnership, when an immovable property is contributed, it must be in a public instrument. All other contracts requires merely that the agreement must be reduced to writing. What are those? Donation of personal property, the value of which exceeds 5,000 pesos, sale of land through an agent, stipulation to pay interest. So these are the formalities required by law, either in writing or in a public instrument. Now, the law may also require that a certain form for the convenience of the parties in order to make effective as against third persons. So sometimes the law will require that a certain contracts be executed in a certain way for the convenience of the parties or to make it effective as against third persons. Now, the special form is not an indispensable requirement since they are allowed by law to compel the other party to observe the proper form, and this right may be exercised simultaneously with the action to enforce the contract. Now, for example, a contract has not been reduced in writing, then a party may compel the other party to observe the proper formalities required by law. And for example, what is the remedy if a party would want to implement or to execute the contract, but the contract has not been reduced into the formalities required by law? Can the party directly file an action to enforce the contract simultaneously, pray for the party to execute the proper formalities required by law? In other words, class, can you file a complaint to enforce the contract and at the same time to reduce the contract into its proper form? The answer is yes. No? Both the action to enforce the contract and the action to compel or to order the other party to compel to observe rather for the proper formalities required by law, that is allowed. We go to Article 1358. Okay. Under Article 1358, the following must appear in a public document. First, acts and contracts which have for their object the creation, transmission, notification, or extinguishment of real rights over an immovable property, sales of real property, or an interest therein is governed by Articles 1403, number 2, and 1405. 2. Cession, repudiation, renunciation of rights, or those of conjugal partnership of gains. Third, the power to administer property or any other power which has for its object an act appearing or which should appear in a public document or should appear in a public document or prejudice a third person. Fourth, cession of actions of rights proceeding from an act appearing in a public document. All the contracts where the amount exceeds 500 pesos must appear in writing, even private one. Now, these contracts must be registered, sale or transfer of large cattle, chattel mortgage. Okay. Take note, class, please memorize the enumeration under Article 1358. These contracts are required to appear in a public instrument. Again, when you say public instrument, this must be duly notarized. No? Acts or contracts which have for their object creation, transmission, notification, or extinguishment of real rights over an immovable property, while the sale of real property or any interest therein is governed by the statute of frauds in Article 1403, paragraph 2 and 1405. Cession, repudiation, renunciation of real rights over conjugal partnership of gains, and the power to administer property or any other power which has for its objects an act appearing in a public document or should prejudice a third person. Cession of actions of rights proceeding from an act appearing in a public document. Okay? Okay. Now, class, we're done with form of contracts. We will go to defective contracts. The first form of defective contracts is under Chapter 6, Receivables Contracts. What is a rescissible contract? A rescissible contract is that validly agreed upon, but because all the essential elements exist, therefore legally effective, but the remedy of rescission is granted in the interest of equity. So class, a rescissible contract, although defective, is actually valid. Now, it is a valid contract. Now, although it is a valid contract, the law gives the other party or the aggrieved party the remedy of rescission. When you say rescission, it means cancellation of the contract, no, in the interest of equity. So otherwise stated, a rescissible contract is a valid contract, but because of interest of fairness and equity, no, fairness and equity, then the aggrieved party is granted the remedy of rescission. When you say rescission, this is a remedy granted by law in order to secure reparation of damages by reason of restoration of things to their same condition prior to the celebration of the said contract. Now, what are the requisites of rescission under Article 1380? No? 1, the contract must be validly agreed upon. Second, there must be a lesion or pecuniary prejudice to one of the parties or to a third person. Third, the decision must be based upon a case especially provided by law. Fourth, there must be no other remedy to obtain reparation for the damage. Fifth, the party asking for rescission must be able to return what he is obliged to restore by reason of the contract. 6, the object of the contract must not legally be in the possession of third persons who did not act in bad faith. And 7, the period for filing the action for rescission must not have prescribed. Memorize the requisites of rescission. No, I will repeat. Now, the gravamen of rescission, the most important requisite is that there must be a lesion or pecuniary prejudice or damage to one of the parties or to a third person. When you say rescission, rescissible contracts, this would generally refer to contracts wherein there is an economic damage to one of the parties or to a third person. Now memorize the requisites of rescissible contracts. Now, what are the types of rescissible contracts? 1, contracts entered into in behalf of wards. 2, contracts agreed upon in representation of absentees. 3, contracts undertaken in fraud of creditors. 4, contracts which refer to things under litigation. So these are the 4 types of rescissible contracts under Article 1381. Now, first, contracts entered into in behalf of wards. Who are wards, class? These are persons who are under guardianship, no, of another, meaning they cannot act on their own because of some incapacity. They cannot enter into a contract, no? So wards are under the supervision, custody of a guardian or legal guardian. And then second, contracts entered upon in representation of absentees. Absentees are persons who does not appear after a lapse of a sufficient lapse of period of time. Third, contracts undertaken in fraud of creditors. Now, what do you mean when you say in fraud of creditors? When you say in fraud of creditors, this is an act of the debtor in trying to dissipate or to alienate all his properties beyond the reach of the creditors. So contracts undertaken in fraud of creditors or what is known in law as fraudulent alienation of property by the debtor, then that contract which is undertaken in fraud of creditors is a rescissible contract, meaning to say the creditors, despite the alienation of the debtor, can ask the court to cancel or rescind the contract. Now, fourth, contracts which refer to things under litigation. Now, what are the requisites of rescission of contracts undertaken in fraud of creditors? One, there must be an existing credit prior to rescission, though it is not yet due or demandable. In other words, class, there must be a debt or an obligation prior to rescission. It does not matter whether the obligation is due or demandable or otherwise. Number two, there must be fraud on the part of the debtor. Fraud, when you say fraud, there is deceit. No? It may be presumed or proved. And third, creditor cannot recover his credit, not being required that the debtor is insolvent. So memorize these requisites of rescission of contracts undertaken in fraud of creditors. Now, what are other instances where contracts are rescissible? Number one, partition. When any of the co-heirs received things valued at least 1/4 than the share he is entitled. So class, for example, if a person dies, then all his properties will be transmitted or vested to his legal heirs. Now, when the properties are vested or transmitted to the heirs, there will have a co-ownership among the heirs. In other words, all heirs will become co-owners of the property. Now, if an heir over the property will receive a value of his share at least 1/4 lesser than the share that he is entitled to, then he can ask the court to rescind the partition among the co-heirs. Because if there is a lesion or economic damage of at least 1/4, then the contract becomes rescissible. Two, if the lessor or lessee should not comply with their obligations. So this is a contract of lease. Now, a contract of lease is where a property is the possession and enjoyment of a property is transferred to another upon payment or for a payment of the rental fees or the consideration. No? Now, if the lessee will not comply with the stipulations in the contract of lease, then the lessor can rescind the contract. Likewise, if the lessor fails to provide his part or undertaking in the contract of lease, then the lessee has the right to ask the court for rescission of the contract. Now, third, the vendee may rescind when the real estate sold is less than or exceeds 1/10 of the agreed price. So in a contract of sale or deed of sale of real property, when the parcel of land sold is less than or exceeds 1/10 of the agreed price, then the vendee or the buyer may ask the court to rescind the contract. Okay. Now, payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled. Now, class, when a person is in a state of insolvency and despite insolvency, the debtor would still settle his obligations. No? That payment made by an insolvent debtor is rescissible. No? Now, in relation to the Financial Rehabilitation and Insolvency Act class, if a person files a petition for insolvency to the regional trial court and the regional trial court issues a commencement order, no? Once a commencement order is issued by the insolvency court or the court handling the insolvency proceedings, then there is what you call as a suspension of all payments, meaning the debtor may no longer touch his properties in order to settle the debts because the debts will be paid in accordance with the rehabilitation plan as approved by the court. Now, any and all payments made by an insolvent debtor for obligations to whose fulfillment the debtor could not be compelled, then that payment becomes rescissible. So take note of this Article 1382 and relate it to the provisions on the law on Financial Rehabilitation and Insolvency Act. Okay. When a debtor is insolvent, then there must be a judicial declaration to that effect. Let us go to Article 1383. Rescission class as a remedy is only a subsidiary remedy. What do you mean when you say that rescission is only subsidiary? What is the counterpart of the term subsidiary? The counterpart is primary. Now, when you say primary, that comes first. When you say subsidiary, that comes next after the primary remedy. Now, when you say rescission is only subsidiary, that means that rescission can be availed only when proved that there is no other legal remedy aside from rescission. Now, even if the contract is considered as rescissible under Article 1381, but there are other remedies that an aggrieved party can avail of, then rescission would not be an available remedy. Why? Because rescission is only subsidiary. Now, it is only available when there is no other legal means to resolve or to aid the aggrieved party. When there is an available remedy, then rescission is not available despite the fact that the contract is rescissible under Article 1381. Okay? For example, if the damage has been repaired, for example, when a party suffered a lesion or an economic damage of 1/4, and that damage has been repaired, then rescission cannot take place. It's no longer an available remedy. Okay, let us go to Article 1384. What are the extent, effect, or reason for rescission? Now, rescission is only up to the extent of creditors' unsatisfied credit. So, for example, an insolvent debtor which is judicially declared to be so, will pay another person, 50,000 pesos, and there is a creditor, who filed a claim with the insolvency court, and she is owed for let's say 25,000 pesos. Now, can the creditor rescind the entire payment made by the insolvent debtor for 50,000 pesos? Answer, no. Rescission is only up to the extent necessary in order to satisfy the creditor's claim, not the entirety of the payment. Now, what is the effect of rescission? The entire contract need not be set aside if damage can be repaired or recovered by partial rescission. In other words, class, the applicability of rescission under Article 1381 is a conservative application. What do you mean when you say conservative application? That means that if partial rescission can be resorted to, then the law will not allow complete rescission. No? Okay. Let us go to the reason of rescission. Now, the law is to preserve or respect the contract and not to extinguish it. Okay? There is no obligation to restore if nothing has been received. When the court declares a contract rescinded, the parties must return to each other the object of the contract with its fruits and the price thereof with legal interest. So class, if there was total rescission, what is the respective obligations of the parties? Number one, the other party must return the object of the contract. Now, aside from the object of the contract, what else needs to be returned? The fruits of the object and the price thereof with legal interest. Okay. Now, under Article 1385, the law likewise enumerates the different circumstances wherein rescission is not allowed. One, if the party who demands rescission cannot return what he is obliged to. Now, since when the court declares rescission, both parties are required to return what he has received, then if a party is unable to return what he is obliged to, then he cannot ask for rescission. Two, if the property is legally in possession of a third person who acted in good faith. So for example, in a contract, it has been transferred to another person after it was transferred as between the parties. A third person is a person other than the contracting parties. What if the object of the contract has been found in the possession of a third person and that third person does not know that that object or that the contract as between the first parties are rescissible? That is, he acted in good faith without knowledge of the transaction as between the original parties. Now, if the property subject of a rescissible contract is later on found in the possession of a third person, and that third person does not have the knowledge that the original parties have a rescissible contract, or has circumstances affecting the validity of the contract, then rescissible or rescission as a remedy is not allowed. In other words, the contract, although it is rescissible, the court will not allow rescission of the contract. Why? Because that third person who does not have any notice or knowledge as between the transaction as regards the original parties acted in good faith. Okay. Now, in contracts entered into in behalf of ward or absentee, rescission cannot take place when the court approved its validity, even if there is lesion or not. Reason, the law presumes that the court acts in the interest of the ward or absentee. Now, under Article 1387, alienations presumed in fraud of creditors. Now, class, for example, a debtor will transfer his ownership by gratuitous title, then there is a presumption that the alienation has been made in fraud of creditors. These are the different circumstances denominated as badges of fraud, or when we say badges, these are hallmarks of fraud. One, the consideration of conveyance is fictitious or inadequate. When, for example, a house and lot has been transferred or sold for half of its price, the consideration is fictitious or inadequate. When you say fictitious, although the contract states that the house and lot was paid in its full price, then there is no such payment. That is what you mean by the term fictitious. It does not exist at all. So when the consideration is inadequate, or worse, it is fictitious or it does not exist, then it is a circumstance as a badge of fraud. Now, number two, a transfer made by a debtor after suit has begun and is pending against him. So, for example, if a person has been sued in court or a case has been filed against him, and subsequently after the filing of the complaint, that person begins to alienate his property, to transfer his property to another person, no, while the case is pending, then that circumstance is also a badge of fraud. Then the creditor can rescind the contract. Third, a sale upon credit by an insolvent debtor. Four, the transfer of all his property by a debtor when he is insolvent or greatly embarrassed financially. Five, the transfer is made between father and son when there are present some or any of the above circumstances. Five, the failure of the vendee to take exclusive possession of all the property. Six, it was known to the vendee that the vendor had no property other than that sold. Now, under Article 1388, the purchaser in bad faith must return the same if the sale is rescinded. And should it be impossible for him to return it due to any cause, he must indemnify the former. Okay. On the other hand, if when there are two or more, then the first shall be liable and so on successively. Now let us go to Article 1389. What is the period in filing an action for rescission of contracts? As a general rule, an action to claim rescission must be commenced within 40 years from the date the contract was entered into. There are exceptions. When the person is under guardianship, then 4 years will commence to run upon termination of incapacity. So for example, the person under guardianship is a minor, then the 4-year period will only commence to run upon attaining the age of majority or the legal age. Now, if a person is an absentee, then if his domicile is known, then the 4-year period will commence to run. Now, who are the persons entitled to bring action? One, the injured party or the defrauded creditor. Two, his heirs, assigns, or successors in interests. Three, the creditors of the above entitled to subrogation. Okay. So these are the persons entitled to bring action in a contract, in a rescissible contract. So next meeting, we will discuss the other defective contracts. Now we will start with voidable contracts. So this is our coverage for today's meeting. I'll see you again next week. Thank you for listening and have a nice day.